live from the drama-free true crime destination. It's the time where every story finds its edge, every opinion lands with weight, and every moment leads here. This is the final word. And welcome to this special late night edition of the final word here at Bethea'S Byte Reloaded, the drama free true crime destination. I'm Ernest Bethea, the last outlaw. It's so good to have everyone on board. And tonight I've got 4 stories I'm going to look back at, and I have some editorial comments to go with each. So, if you're joining me, welcome. It's so good to have you. Let's go ahead and get things underway. We begin with a story you may already be familiar with. That of young Quinton Simon, a 20-month-old toddler whose life was taken by his very own mother, Leilani Simon. Leilani was brought to trial. She was convicted and sentenced to life in prison with a possibility of parole in 40 years. Well, guess what? Leilani Simon wants a new trial. A Georgia mother convicted of murdering her toddler son, whose remains were found in a landfill, is asking for a new trial. Last year, a jury convicted Leilani Simon on 19 charges, including murder, concealing a death, falsely reporting a crime, and 14 counts of lying to investigators in the death of 20-month-old Quinton Simon. She was sentenced to life in prison with the possibility of parole after 40 years. The case began on October 5th, 2022, when Leilani called 911 to report her son Quinton missing, telling a dispatcher she believed he had been abducted from their home. After weeks of searching, investigators found the toddler's remains in a landfill on November 18, 2022. Prosecutors argued that Leilani was upset after being rejected by her boyfriend and using drugs when she killed Quinton. In their motion for a new trial, Leilani's attorneys claimed their statements to police were wrongly admitted after the court denied a motion to suppress. They also argued that the court erred in allowing certain evidence about Leilani's alleged sexual relationship with an alleged drug dealer that was previously ruled inadmissible. During the cross-examination of Leilani's ex-boyfriend, Daniel Youngkin, the state argued that the defense opened the door for said sexual evidence, and the court reversed its prior rulings, which allowed prosecutors to show the jury explicit text messages between Leilani and Craig Weston. In their motion, the defense argues the unfair prejudice of unrelated salacious sexual activity substantially outweighed any probative value. The motion further states the verdict was contrary to the evidence and without evidence to support it. A hearing has been scheduled for January 9th, 2026. Now, friends, you know me. You knew with her case, I would have a lot to say about it. So here's what I'm saying here. In the quiet hours, the past has a way of knocking on the door. But some doors should never be opened again. Leilani Simon wants to reopen her past. She wants a new trial. She wants the record rewritten. But Quinton Simon doesn't get that opportunity. His story ended in a landfill. His voice silenced before he could form the words to defend himself. The law will weigh her request. Motions will be filed. Hearings will be held. no courtroom can undo the truth after that a child is gone, and no verdict, past or future, can restore the life that was taken. We talk about justice as if it's a scale, but in cases like this, the weight is always uneven. One side holds the possibility of appeal, while the other holds a boy who will never see another birthday. And that, ladies and gentlemen, is the part we can't reopen. That's the part we can't fix. And that's the part we must never forget. So, as a reminder, the that hearing for Leilani Simon's motion for a new trial, that'll be set on January 9, 2026. And God willing, I will be here to cover that. Next up, the copycat of that case. Just to keep you in mind. Just to keep in mind, I keep mentioning this as a copycat, and in a way it is. Emmanuel Haro is still missing. They still haven't found him yet, and there is so much going on that. But in the meantime, his parents, Jake and Rebecca Haro, have pled guilty. No, excuse me, not guilty. So I'm gonna take you to that, and I am going to give you my thoughts on that as well.
We have received a copy of that felony complaint. Stipulate Mr. Haro has been advised of his legal and constitutional rights, waive formal reading and advisement, enter a not guilty plea, and now for appropriate
receipt of the complaint in this matter stipulate that her name and date of birth are set forth correctly, and that she has been advised of her legal and constitutional rights. I would ask that not guilty please be introduced to both counsel in this matter.
The parents of baby Emmanuel Haro faced a judge on Thursday, charged with the murder of their missing 7-month-old son. They pled not guilty to those charges. Jake and Rebecca Haro are accused of killing Emmanuel and filing a false police report in connection to the infant's disappearance. After pleading not guilty, the couple is going to be behind bars with bail set at $1 million. Here are some upcoming key dates for Jake and Rebecca Haro. Felony Settlement Conference. That's going to take place pretty soon. September 16th is the date for that. The preliminary hearing will be September 17th, and then the pretrial hearing is going to be September 18th. So important dates coming up in that case. Baby Emmanuel has been missing since August 14th. The location of his remains, they're still unknown. He is presumed dead by investigators, something the district attorney talked to the media about after Jake and Rebecca Haro were arrested.
Do you believe you know how baby Emmanuel died or was killed, and is there anything you can share?
The filing in this case reflects our belief that baby Emmanuel was abused, a victim of child abuse over time, and that eventually, because of that abuse, he succumbed to those injuries.
Now that we know that Jake and Rebecca Haro are pleading not guilty, what's the possible defense for the accused parents? Why don't we go ahead and bring in our guests for this hour. Criminal defense attorneys Joe Tamburino and David Bruno are still with us, and also joining the program, private investigator Manuel Gomez. Gentlemen, thank you so much for being with us this morning. Manuel, I'm going to start with you. We have been wondering where baby Emmanuel is. The parents are not providing any sort of information. How do you take a look at a case like this?
Well, due to the fact that Jake Haro has been lying to the police. He's already told them that his son is dead, and that's why he was seen at another location looking for the body off the highway. He's been misleading the police. So due to the fact that we're dealing with a chronic liar, all right, what we need to do is go back to the digital footprint of the mother and father, and that's going to give us the possible leads of where this baby was taken. Also remember, before she made this complaint, she was at a location where they were doing it at a construction site, which is ideal because there was cement there, cement ditches being dug, and that she could have dropped off the body there. But again, that digital footprint is going to give them where the locations that baby could possibly be buried. The fact that they both pleaded not guilty is insane because, again, Jake Haro told the police his son is dead and took them to a location to where the body possibly could be. The circumstantial evidence in this case is overwhelming.
David Bruno, let me bring you in on this. They did plead not guilty. What's the possible defense? What is the strategy behind that?
No surprise on the plea from me, at least. That's the constitutional right. Every defendant has. They're presumed innocent. But here's my mindset from a prosecutor standpoint. Which one's going to give the information? You know, it looks like the dad had a very serious prior abuse conviction with another child, infant, that left her permanently damaged and bedridden. So he's got a propensity. So he is probably the #1 suspect target in the most of the conduct. So I just wonder how long it's going to be for mom to come forward with her lawyer with information that could be helpful. Assuming the facts are that dad was more culpable, the prosecutors will probably be looking for either of the two with less culpability to provide information about the location of the body, as well as information as to the cause and manner of death for the murder prosecution of the other. So I think that's what prosecutors are thinking about right now, given the fact that they don't have the body.
Joe, what's your take on this? They pled not guilty.
Yeah, I'm going to go, well, first of all, they're not guilty. David's right. I mean, it's a constitutional right. There could be a video of you robbing the bank and you could go to court the next morning and say not guilty. It's basically just a legal maneuver. However, I'm going to go a little bit further with what David was talking about. I think, I can't guarantee this, but based on all my experience, I think the prosecution is likely reaching out to Rebecca's attorneys to see if she would turn on Jake. I just don't have a doubt about that. Why wouldn't you? When you're a prosecutor, what you try to do is get the most culpable guy. Yes, you want to convict everyone who's part of the whole conspiracy, everyone who has dirty hands, but you have to triage. You have to say, I want the guy who's the most guilty to go away for the longest period of time. And it appears in this case, just based on what we know, that would be Jake because he's got the prior conduct and everything. So I would think the prosecutors are going to Rebecca's attorney saying, look, let's make a deal. She provides the information. She testifies against Jake. She gives us the possible locations of where poor Emmanuel was buried, and we cut her a deal.
Now, after the arrest of Jake and Rebecca Haro, District Attorney Michael Hester, he had this to say about the decision to release Jake from custody. This was prior to the disappearance of Emmanuel. Why don't we go ahead and listen to that?
In this case, a judge here in Riverside County, happened to have been a visiting judge from San Bernardino County, gave Mr. Haro a suspended sentence, which means, if I can translate for you what that is, it means that instead of sending him to prison, he chose to give him probation. I will say that it was an outrageous error in judgment by this judge. And I don't have any problem saying that. I'm not attacking the judge personally. That decision was absolutely outrageous. Mr. Haro should have been in prison at the time that this crime happened. And if that judge had done his job as he should have done, Emmanuel would be alive today.
Court TV has reached out to the district attorney's office since that news conference. The office has not been commenting on the matter at this time. I can see why they're not really commenting, gentlemen, but why don't we talk about this, Manuel? I'll go to you. Are we any closer to locating baby Emmanuel, or do you think we're just too far removed from any possible developments on that front?
I don't think we're closer to locating baby Manuel until, like my colleagues just said, until that mother caves in and goes against the father. But she's not going to, because I believe she's suffering from some form of Stockholm syndrome, because she's protecting her abuser. Clearly, she's a mother of domestic violence, and she's doing everything humanly possible to protect her husband, knowing that her child is dead. Okay? But again, like my colleague said, they're going to continue to press her. She's the weakest link, but we don't have any other new leads. And this is why that digital footprint of their telephone locations is important to find this baby, because that father has propensity to lie and will lie and misdirect the police, as he has done so far.
David, we just played that soundbite before, some strong words on the front when this case first broke. What's your reaction to that and letting somebody out?
We're talking about a 2018 child abuse case with another victim who was 10 weeks old at the time of that allegation. And that particular victim has lifelong permanent injuries and is bedridden. He did not get prison whatsoever. And I have to join in the questions about that particular sentence, because if he was treated and he was sentenced to jail, he would not have been around to do this. And also, Child Protective Services has been in this family's life, including with this particular baby. So questions have to be also as to how that was handled and why more wasn't done by Child Protective Services.
Yeah, absolutely. David, thanks so much for that feedback. David and Joe are going to stick around. Manuel Gomez, thank you so much for joining us this hour. Have a great Friday. Thank you for being with us.
Now, there is so much on this, including just given the fact, like I said earlier, this is given off vibes of the Quinton Simon case. I mean, think about this. Emmanuel Haro is still missing. His parents, Jake and Rebecca, are charged with his murder. Rebecca says she was attacked outside of a Big Five sporting goods store. According to Rebecca, a man came to her, said "Hola," and knocked her out cold. When she came to her senses, Emmanuel was gone. Evidence, however, corroborates no such story. No witnesses, no surveillance, no sign of a kidnapping. Just silence. Investigators believe Emmanuel was abused before he died. They believe his body is somewhere out there hidden in the California desert, and they're still searching. Ladies and gentlemen, this isn't just another headline. It's a mirror held up to the cracks in our protection of children. We've seen this before. As I've mentioned, Quinton Simon in Georgia. Now Emmanuel Haro in California. Different names, same pattern, same heartbreak. And until Emmanuel Haro is found, there is no closure. Only questions. Only the desert holding its secrets. So to everyone in that area, let me see if I can pull up the missing persons info on Emmanuel Haro real quick before I go onward. No. Well, maybe I may have to look this up on the FBI's website. Or NCMEC. No. No missing persons flyer. Okay, so I'm just got to make do with what I got. All right. I'm reaching out to all of you in the Cabazon, California area. If you have any information at all on the whereabouts of Emmanuel Haro, as I always say, please do not hesitate. What I want you to do is call 911 immediately. If not them, get on the phone with the FBI's 24-hour tip line. That number, 1-800-CALL-FBI, 1-800-225-5324. You can submit your tip anonymously to the FBI by going to tips.fbi.gov. tips.fbi.gov. You can also get in contact with the National Center for Missing and Exploited Children. That number is 1-800-LOST, 1-800-843-5678. Or you can go to www.missingkids.org to give what information you can. But whatever you do, I beg of you, please, when it comes to this little boy, if you see something, please say something. That way, we can do something to bring Emmanuel Haro home safe and sound. those are the tough cases. But if you thought that, if you really think that's a tough one, I really have to throw this trigger warning up at you, because this is the kind of story that I'm about to bring to you right now is one that will make you sick. Alright. Okay, now that you got the trigger warning, a little preface before this. This is the kind of case I take a little personally because I am a child of adoption. I know what it is, what it's like to be bounced from one home to another and to be abused in that process. But what I'm bringing to you right now is absolutely heinous. I want to use my signature line and extend it a little bit. Kids don't have to worry about the monsters hiding under the bed or hiding in the closet. They walk in broad open daylight most times. And to make it worse, most times they're called mom or dad. Or in this case, mom, dad, big brother, or big sister. Two siblings are facing felony child abuse charges for allegedly caging their siblings beneath their beds, and they appeared in court asking for their bonds to be lowered. They want their bonds to be lowered. Are you kidding me? Dallin and Liberty Griffith are facing charges along with their parents, Brian and Jill Griffith, for child abuse after nine underage children in their home reported receiving extreme punishments and being locked in their beds. Dallin appeared in court first. His attorney told Judge Garrett Hill that prosecutors have agreed to reduce the bond from $500,000 to $10,000. Without editorializing too much, there's levels of culpability in this case. Assistant State Attorney Madison Hodge told the judge the parents are obviously the main culprits. Judge Hill felt $10,000 was too low, despite the agreement, and set Dallin's bond at $150,000. Liberty's bond was lowered to $100,000 when she appeared before Judge Hill. Liberty's defense attorney Bobby Frank also asked the court to authorize the release of interviews conducted by the state's child protection team with the underage children in the home. Prosecutors cited privacy concerns for withholding the recordings. I can't do my job at all right now. I'm handcuffed, Frank said. They hold all the cards, but they don't want to give those cards to me so I can properly defend my client. Hodge explained that the interviews contain allegations of sexual abuse and inappropriate sexual behavior that are unrelated to Liberty's case and should be shielded. There's no relevant materials as far as any evidence that would support the crime, Hodge said. With all due respect, the state doesn't get to make unilateral decisions as to whether something is material to my defense or my client, Frank countered. The proper mechanism is for the court to make that determination. Prosecutors agreed to release 3 interviews to the defense immediately. Judge Hill said he would review the rest privately and determine whether any, should be given to Liberty's defense. Both Dallin and Liberty are due to return to court in October as their cases proceed toward trial. So let me give you a quick recap here. The two siblings involved in the case, and yeah, they are involved. They asked to get their bond lowered. One wanted his to drop like a lead balloon from $500,000 all the way to $10,000. And even the judge said that was too low. So he lowers that one to $150,000 and lowers Liberty's to $100,000. Honestly, if it were me, if I was under that black robe, I wouldn't have given him any bond to begin with. But that's just my opinion and my thinking. Monsters don't always hide in the closet or under the bed. In this case, sometimes the monsters actually build the bed and lock the children inside. In Fort White, Florida, 4 members of the same family, Brian and Jill Griffith, and their adult children, Dallin and Liberty, stand accused of aggravated child abuse against 9 children ages 7 to 16. 5 of those children were their biological kids. 4 were adopted. According to investigators, the adopted children were treated like prisoners. Locked under bunk beds with plywood screwed down, sprayed in the face with vinegar, beaten with a cane, given medications that weren't prescribed, denied schooling so basic some couldn't read, write, or even say their own birthday. The abuse came to light after a mandatory reporter at their church raised concerns, including one child showing up at a church camp with a working stun gun. Excuse me. What investigators found was worse than anyone imagined. A home where cruelty was routine, and where the adopted children were forced into labor while the biological children played. All 4 Griffiths are charged. All 4 are in custody. And yet, the deeper question remains: how many times did the system look away before somebody finally spoke up? But like I said, the monsters don't just build these cages. They build cages in plain sight. And they count on the rest of us not to look too closely. So we still got we're still waiting to see what happens in all 4 of their cases, and I'll be sure to bring you updates, whether it be in a midweek bite, final word like this, hopefully at an earlier time, or any of the Saturday or Sunday bites. But I guarantee you, you're not gonna miss a moment. I've got one last recap left, and let me tell you, this is one of the saddest cases we've had this week. Picture this: a 4-year-old gunned down in a drive-by shooting. 5 men sent to trial. And this week, all 5 men convicted. Well, guys, you don't have to imagine it. I'm going to bring it right to you.
Clerk, if you would publish the word.
State of Florida versus Quindarius Hammond, Devontae Sampson, Jalen Bedward, Andrew Thompson, and James Denson. Verdict form: we, the jury, find as follows as to count one of the indictment as to Quindarius Hammond. The defendant is guilty of the first-degree premeditated murder of Sonny Bell, as charged, and did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count one of the indictment as to Devontae Sampson. The defendant is guilty of first-degree premeditated murder of Sonny Bell, as charged. We, the jury, find as follows as to count one of the indictment as to Jalen Bedward. The defendant is guilty of the first-degree premeditated murder of Sonny Bell, as charged. We, the jury, find as follows as to count one of the indictment as to Andrew Thompson. The defendant is guilty of the first-degree premeditated murder of Sonny Bell, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count one of the indictment as to James Denson. The defendant is guilty of the first-degree premeditated murder, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count two, we, the jury, find as follows as to count two of the indictment as to Quindarius Hammond. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count two of the indictment as to Devontae Sampson. The defendant is guilty of attempted first-degree murder of Mary Harrison, as charged. We, the jury, find as follows as to count two of the indictment as to Jalen Bedward. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. We, the jury, find as follows as to count two of the indictment as to Andrew Thompson. The defendant is guilty of the attempted first-degree murder of Mary Harrison. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count two of the indictment as to James Denson. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count three, we, the jury, find as follows as to count three of the indictment as to Quindarius Hammond. The defendant is guilty of attempted first-degree murder of Willie Brown, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count three of the indictment as to Devontae Sampson. The defendant is guilty of the attempted first-degree premeditated murder of Willie Brown, as charged. Count four, we, the jury, find as follows as to count four of the indictment as to Quindarius Hammond. The defendant is guilty of conspiracy to commit first-degree murder, as charged. We, the jury, find as follows as to count four of the indictment as to Devontae Sampson. The defendant is guilty of conspiracy to commit first-degree murder, as charged. We, the jury, find as follows as to count four of the indictment as to Jalen Bedward. The defendant is guilty of conspiracy to commit first-degree murder, as charged. We, the jury, find as follows as to count four of the indictment as to Andrew Thompson. The defendant is guilty of conspiracy to commit first-degree murder, as charged. We, the jury, find as follows as to count four of the indictment as to James Denson. The defendant is guilty of conspiracy to commit first-degree murder as charged. Count 5, we the jury find as follows as to count 5 of the indictment as to Quindarius Hammond. The defendant is guilty of shooting at, within, or into a vehicle as charged. We the jury find as follows as to count 5 of the indictment as to Zavante Sampson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We the jury find as follows as to count 5 of the indictment as to Jalen Bedward. The defendant is guilty of shooting at, within, or into a vehicle as charged. We the jury find as follows as to count 5 of the indictment as to Andrew Thompson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We the jury find as follows as to count 5 of the indictment as to James Denson. The defendant is guilty of shooting at, within, or into a vehicle as charged. Count 6, we the jury find as follows as to count 6 of the indictment as to Quindarius Hammond. The defendant is guilty of discharge of a firearm from a vehicle as charged. We the jury find as follows as to count 6 of the indictment as to Andrew Thompson. The defendant is guilty of discharge of a firearm from a vehicle as charged. We the jury find as follows as to count 6 of the indictment as to James Denson. The defendant is guilty of discharge of a firearm from a vehicle as charged. So say we all, dated this 17th day of September 2025, signed for pursuant of the jury.
Would the attorneys like the jury polled?
Yes, Your Honor.
Madam Clerk?
Juror number 1, is this your true and correct verdict?
Yes.
Juror number 2, is this your true and correct verdict?
Yes.
Juror number 3, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict? Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict? Juror number 9, is this your true and correct verdict?
Yes.
Juror number 10, is this your true and correct verdict? Juror number 11, is this your true and correct verdict?
Polling the jury guilty on all counts, all 5 defendants.
Started to say all 5 defendants were found guilty on all charges, including the lesser charges. They were found guilty of. They were found guilty of first-degree murder, first-degree attempted murder of Willie Brown, and they were all found guilty of conspiracy to commit first-degree murder. And they were also found guilty of the lesser included charges, including shooting at, within, or into a vehicle. And they were found guilty of discharge of a firearm. It is a sad state of affairs when your need for vengeance overrides the life of a young child. Five men will grow old behind bars, but the little girl they killed will never grow old at all. Her name was Suni Bell. She was all of 4 years old. She loved LOL dolls. She sang in church. She danced. She protected her little brother. In August 2021, her family's car was followed from a gas station in Tampa. Inside that car, Suni sat in the back seat. Behind them, 5 men: Zavante Sampson, Quindarius Hammond, Jalen Bedward, James Denson, and Andrew Thompson, masked themselves up, armed themselves, and opened fire. And in the hail of bullets, one of those bullets struck Suni. She died before she could even understand why. And as you saw in the video clip, earlier this week, a jury found all 5 men guilty. Again, those charges being first-degree murder, attempted murder, conspiracy to commit murder, and shooting into a vehicle. Now, while none of them may have fired the fatal shot, under Florida law, all 5 defendants bear the same weight. Now, they face mandatory life sentences. But I'm here to give you some truth. This isn't justice. It's aftermath. Let me explain why. Justice would have been Suni starting 3rd grade this fall. Justice would have been her laughter echoing in her home. Instead, we'll have 5 wasted lives in prison, 1 stolen life in the ground, and a community left to wonder how many more children will be caught in the crossfire before we decide that enough is enough. For Suni Bell, there are no second chances. And that's why we continue to speak her name. It's a hurting thing. It's really disgusting on its own. Only thing I know now is, from what I've read, and I want to believe, little Suni is flying high with the angels, or even better yet, she is resting comfortably in the arms of our Lord and Savior Jesus Christ. I pray for the family to have peace that surpasses all understanding. And I pray that when the sentencing comes around, this sentencing will indeed fit the atrocity and the sheer cowardice that is a drive-by shooting that claimed the life of a 4-year-old girl. I've got one last bite for you, and then I'm going to say goodnight to you all. One last bite. The monsters don't just lurk in the shadows anymore. They walk in daylight. They smile from family photos. Sometimes the children call them mom, dad, big brother, big sister. In Georgia, Quinton Simon's life ended in a landfill. Across the country in California, Emmanuel Haro is still missing. His story a mirror image, only without the closure of a grave. 2 children, 2 states on opposite coasts, 2 sets of parents accused of the unthinkable. One has yet to stand trial. The other wants a new trial to rewrite the record. Remaining in the Sunshine State, 9 children were locked beneath beds, beaten, drugged, and denied the basics of life. All by the very people who were supposed to protect them. Now they're about to face trial. Still in Florida, 5 men decided that vengeance was worth more than a little girl's life. While they will grow old behind bars, 4-year-old Suni Bell, however, will never grow old at all. Ladies and gentlemen, these are not just stories. They're warnings. They are proof that evil doesn't always hide. Sometimes it lives right next door. If we don't keep speaking, if we don't keep looking, if we don't keep fighting, the next thing we say could be one that we know. That's one last bite. And that's the final word. I want to thank everyone for joining me for this edition of The Final Word. And I hope that I will see you again soon. Until then, I'm Ernest Bethea, the Last Outlaw. And as always, this is Bethea'S Byte. And it's reloaded.
Thank you all for joining me here at the Drama-Free True Crime Destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.